Okay, welcome back, everyone. My name is Todd Hutchins. I'm the president of Catholics at Bolt here at the University of California Law School. It's our pleasure today to be co-hosting with the American Center. We have a wonderful panel. Judge McConnell did an outstanding job of providing all of the background. There was an impassioned cry right before we broke up. Can this Blaine Amendment, which says that the state cannot provide any funding to religious organizations, and when that was aimed specifically at Catholics, can something that insidious be legal? And that was a great question, and that is the basis for this panel today. Now, it's a panel of all-stars. Clearly, we've still got Judge McConnell up here. We have Eric Rassbach, who is the litigation director at the Becket Fund, and he's been described by geniuses as the mastermind of challenging Blaine Amendment type things. And then we also have Professor Jesse Choper, who is a legend in his own right in constitutional law, and also Richard Komer from the Institute for Justice. And with that, I'll turn it over to Eric Rassbach starting us.
Thanks. First of all, I just want to clear up that I'm not a mastermind. That has somewhat evil-sounding overtones, so I may have to talk to Professor McConnell about that afterwards. So I've been given I'm going to talk about two sort of disparate, they're obviously connected, but two disparate topics, and I think I have 10 to 12 minutes, and we're behind schedule, so I'm going to talk fast. The two topics are Blaine Amendments, which Professor McConnell gave some historical background on, and then the other one is about charter schools and navigating church-state issues for public charter schools. So on Blaine's, our organization, the Becket Fund for Religious Liberty, we're a law firm in Washington, D.C. We litigate on behalf of people of all different religious backgrounds. We say Anglicans to Zoroastrians. And we litigate around the country and actually overseas as well. And we've been involved with Blaine Amendments. We run a website called blaineamendments.org that explains why they're a nasty history and why they're a bad idea, why they should be gotten rid of. But we're also involved with legislative efforts in different state houses to repeal their Blaine Amendments. They exist in about 40 states around the country. After the failure of the Blaine Amendment to pass Congress as a federal constitutional amendment, they were then enacted in many different state constitutions, often as a condition of entry into the Union. So if South Dakota wanted to become a state, they had to put a Blaine Amendment in their state constitution saying that no sectarian organization could receive state funds, which, of course, as Professor McConnell pointed out at the time, meant Catholics. So Catholic schools could not get money, but you could still have Protestant, what I think of as Protestant light religious services at the public schools across the country. So what happens with the Blaine Amendments? They basically sit there in the state constitutions. There's the question earlier, the impassioned cry, I believe, that about why is it that there's not a lawsuit? Well, I can tell you it's not for lack of trying. The problem is that, for the most part, Blaine Amendments are used as a kind of terrorizing part of the state constitutions when talking to legislators. So they don't actually get litigated very often because it's very infrequently that you get a state that would pass a law that gives some funding that say to religious schools, and basically in the face of a Blaine Amendment. And it's particularly because basically what happens is the bill gets put up there, legislative council is asked, well, is this constitutional? They always have to run it through some sort of constitutional system. Legislative council comes back and says, oh, you can't do this, there's a Blaine Amendment on the books. So what ends up happening is that the laws that might violate a Blaine Amendment and thus bring the Blaine Amendment's own constitutionality into question, that is, does it violate the federal Constitution because of its clear anti-Catholic origins, it just doesn't end up coming up. And the other thing I'll say is that in litigation, judges bend over backwards to avoid getting into this topic. It's not something that they want to deal with. So if a case can be kicked out on any other grounds, they will do that and not reach the issue. In part because of the laudable principle of law that if you don't, federal courts would not want to be in the business of overruling or ruling unconstitutional state constitutional provisions. That's the last thing they want to do. So you'd have to get a really squarely presented case. What's the upshot of all this? What it means is that Blaine cases are as scarce as hen's teeth, and they don't ever really reach the constitutionality issue. I won't get into the sort of legal theories about why it's why we think they're unconstitutional as applied in this forum, but I'd be happy to talk to anybody about it offline. But what I can say is there's a trend right now, which is that there is a little bit of an increase in the attempts by secularist plaintiffs, that is people that want to impose a vision of secularism through lawsuits, to use Blaine Amendments, precisely because the federal Establishment Clause has been getting interpreted in a slightly different way in the last 20 years. So as the scope of the federal Establishment Clause shrinks, suddenly, the tide recedes, you start seeing these Blaine Amendments lying around. And we're actually involved in a case, for example, in Florida, where the Council for Secular Humanism, which is a New York state group, has sued the state prison system for giving funds pursuant to a contract for rehabilitation of recently released prisoners. And these are programs where both religious and secular organizations participate, but they're suing because our clients have the names Lamb of God Ministries and Prisoners for Christ. And they're paid to provide rehab services if the prisoners who freely choose to be there or not. It's basically just a benefit that they can choose to take or not. If they leave, they're okay. Basically, this ministry doesn't get any money. So they're suing under the Blaine Amendment because that's the last thing left for them to do. It's clearly constitutional under the federal Constitution. So you could actually see a lawsuit. And we're getting involved in every lawsuit that we know about, and if you know about one that we're not involved in, I would appreciate hearing about it. But ultimately, I think the message about Blaine Amendments is that the place where I think all of you could probably be the most effective and the way that you get results more quickly is in the legislative process. And that is to point out the anti-Catholic origins of the Blaine Amendments, the fact that they are vestigial laws that are still on the books from a time of prejudice, much like Jim Crow laws actually still exist on the books of some states, and that they really need to be repealed because they are a black mark on the record of that state. And that's exactly what's happening right now in Florida. It's actually quite likely in the next few weeks that there will be floor debate and a vote on a ballot measure to repeal Florida's Blaine Amendment. And I could say that we were heavily involved with getting that drafted and put before them. Now, of course, I am not an expert on Florida legislative procedures, so I can't guarantee a single thing. But that's just to say that making this argument and making it about that history that Professor McConnell was just talking about is actually effective. And there's other places that are taking it up to varying degrees of seriousness. Missouri, Georgia, Nevada are all interested in this. So that's something where people can have a real effect right now. And frankly, even having a legislative victory would have some effect on the litigation angle as well. If you can show that people are recognizing this history, that does have an effect on how the courts will interpret it. So that's what I would say about Blaine Amendments and trend-wise, and I'll be happy to answer questions later. So now moving on to charter schools. Our involvement with charter schools is that we advise a number of schools that are navigating church-state issues, public charter schools, Florida and New York and elsewhere. And several of them are Hebrew language, dual language charter schools. So everyone learns Hebrew at the school. And when these schools were proposed, both in Florida and in New York, they were accused of being Jewish day schools in disguise, and that you could not teach Hebrew, for example, in an academic fashion. I was actually at a meeting of the Broward County Public School Board where I was testifying, and then a rabbi was testifying from a school that considered my client to be a competitor, and he got up there and said, "You cannot teach Hebrew in a non-religious way. It's impossible to teach Hebrew as an academic subject." I found that interesting because I went to a public high school in Houston, Texas that was a language magnet school, had 8 different languages, and it's been teaching Hebrew for about 30 years. So I thought that was very interesting, that's the argument that would be made. And that's a really important thing for anybody out there that's involved with charter schools to think about, just as a practical issue, is that the Establishment Clause will be used as a method of attack on your school no matter what the motivation. They may not care about the religious issue. They may just be, not believe in having charter schools, or they think they're bad for teachers' unions, or what have you. But they will use the Establishment Clause and abuse it, in my view, to attack your school. I'm not going to get into all the various issues that come up. I would say that one issue that's very prominent, or 2 issues that are very prominent, are religious aftercare programs and what are called charter conversions. So religious aftercare programs are private aftercare programs that a parent can opt to pay for to have their kids stay at school, or usually actually off-site from the school, to get actually sometimes non-religious training or religious training after school. Aftercare is a very important part of a lot of different school systems, as many of you probably know. And those can exist as a complement to a public charter school. Current law says you can't have the government funding religious instruction that may have historically faulty foundations, but right now that's the governing rule. But you can have these complementary programs that would not be run by the school, but be run by a private organization, even a parent's organization at the school. And that's something that I just want to throw out there, that is a way that in a school, in a public charter school context, you could have a sort of the church and the state coming alongside one another and working towards the overall goal of educating the child. The second issue that I was going to talk about was just charter conversions. And this is something that's come up with, for example, a number of Catholic schools. They've, because of the financial situation with Catholic, especially urban education, some dioceses have seen it necessary to figure out how to pay for, still educate kids, but pay for it. And they've done charter conversions. So, for example, the Archdiocese of Washington did this. And that's something that can be done. It just has to be done very carefully. And I think that the one thing that people have to keep in mind, if you're a religious organization thinking about this, is that your school won't be a religious school anymore. So you have to decide that that's what you want to do before doing it. But I think that that's one issue where you're going to see a lot of controversy and litigation. I know that there was a lot of attention to it in Washington, D.C. when it happened a couple of years ago. My main point would be, if you're someone in one of these situations, get a lawyer early on. It's not something that takes a ton of time to deal with, but it's something you need to think about ahead of time. What do I think will happen with charter schools and navigating church-state issues going forward? Well, so far there's only been one major case involving litigation, and that's the Tisa case that Professor McConnell mentioned earlier in Minnesota. And I won't speak to that case since it's his case, but I will say that a lot of charter schools around the country are watching that case extremely carefully because it could set a very bad precedent, or it could just end up being nothing. And really what I see the overall issue being is whether charter schools and faith-friendly charter schools are going to be okay is can they build enough of them before you get an adverse decision? If you get an adverse decision and there's not many, then the ideal will be shot down. But if there's hundreds of them around the country, it will be seen as a rogue school, and the principal won't be shut down. Anyway, I've run out of time, so I'll leave everything else for Q&A.
So my name is Dick Komer, and I would like to be considered a legal mastermind, but I'm not. Like Eric, the Institute for Justice deals with Blaine Amendments on a daily basis, and I have to confess that I was a little shocked that he said, there are not a lot of cases, because we've actually litigated a bunch of them, because they come up in school choice defense all the time, because there's 40 states with Blaine Amendments. There's about 30 states with compelled support clauses. And until today, I always thought of compelled support clauses as less of a problem. But Andrew Coulson seems to think that they're more of a problem. However, we've litigated them too, and generally speaking, with one big exception, we win the cases under the compelled support clauses. First, I'd just like to mention that it's kind of a thrill for me to be here today, because what we do at IJ is help states draft school choice legislation, and then if they actually pass it, we then defend it in court, because it's almost invariably challenged unless it involves special ed kids, because nobody likes to take away benefits from special ed kids, even the teachers' unions. So, we've been defending these things for a long time. We participated representing parents in the Zellman decision that established school choice as constitutional under the Establishment Clause back in 2002, in which, among others, Dean Choper filed an amicus brief on our side of the issue. And we're currently litigating the only school choice case the Supreme Court has this term, which is Arizona Christian School Tuition Organization versus WIN, otherwise known as the WIN case, in which the American Center for School Choice filed an amicus brief. The Cato Institute filed a great amicus brief. I should say all of them were great, but theirs was terrific too. And various other organizations represented here today filed amicus briefs, like the Becket Fund. Also, you probably aren't aware of it, but I have this little office in Washington, and I have a couple dozen books on school choice, and I'd say a good half of them are written by people who have spoken here today or who are in this room. And I'm delighted to hear that Charles Glenn is going to write a couple more books, or has written a couple more books, because now I can get rid of my Diane Ravitch books and replace them with Charles Glenn books. You have to know Diane Ravitch to know why I said that, but we won't go there. But just to illustrate a point about Blaine Amendments, I went, in getting ready for this conference, to the website, and got to the third paragraph and choked, because I found this sentence. Only 12 states and the District of Columbia have enacted programs that provide public dollars, mostly to low-income families, which enable these families to choose a faith-based school. These 20 programs, 11 scholarship and 9 tax credit programs, operated through nonprofit organizations, blah, blah, blah. What's wrong with this statement? The tax credit programs are included as programs that provide public dollars. That's not how we defend tax credit programs. We defend tax credit programs on the basis that they don't provide public dollars, that they simply encourage private giving to third-party organizations that grant scholarships, like the program in Florida that has been discussed. Because if you're providing public dollars to private schools, that runs afoul of Blaine Amendments. And the whole development of the school choice sort of jurisprudence since Everson has been an increasing refinement of the idea that you can aid families, you can aid parents without being in the situation of providing aid to the schools. They may receive incidental benefits. The Supreme Court accepts incidental benefits as not violating the Establishment Clause, but you cannot aid the schools directly the way that you aid other organizations directly as organizations. You cannot give a grant to a school, but you can provide benefits to families that empower them to choose. And so we're always very concerned that in talking about school choice programs that we emphasize that the funding is for the families are the beneficiaries, the schools are merely providing educational services to those families the same way that they provide educational services to school districts. When school districts contract out some of their special ed kids, for example, to private schools. That doesn't violate the Blaine Amendment, and neither does it violate it when we give the money to families. So we're very conscious of that. Now, we have defended challenges against Blaine Amendments, and Eric is absolutely right that it's used in the legislatures to try and squelch the passage of these things, but sometimes they pass. And many states have interpreted their Blaine Amendments to parallel the Establishment Clause standards, which means they accept the idea that you can aid families without aiding the schools and running afoul of your Blaine Amendments. Example, the first modern school choice program is in Milwaukee, Wisconsin, and Milwaukee has a Blaine Amendment. Wisconsin has a Blaine Amendment. They have a compelled support clause, too. And both were used to attack the program as unconstitutional under the state constitution. With respect to both, the Supreme Court of Wisconsin held that both of those provisions restrict the state no more than the Establishment Clause does. Similarly, when we were trying to defend the Opportunity Scholarship Program in Florida, a Blaine Amendment attack was brought under their Blaine Amendment, and we even lost that at the Court of Appeals. When we appealed it to the Florida Supreme Court, apparently they thought that they were on such weak ground using the Blaine Amendment because, quite frankly, in 3 earlier decisions, they had interpreted their Blaine Amendment to parallel the Establishment Clause. They declined to strike the program down on the Blaine Amendment. They instead chose to radically reinterpret a different provision of their education article in their Constitution and say this article prohibits any funding for education on anything except the public schools. A very different kettle of fish. They also said, of course, we don't mean to invalidate the special ed voucher program, and we don't mean to invalidate the tax credit program, which has now grown to 34,000 kids. And so what this illustrates is that the Blaine Amendments were intended to be a barrier, but they were also intended to prevent a very specific thing, which was equal funding of Catholic schools at a time when the public schools were generically Protestant. It also illustrates that just because you can't have a scholarship program because of a Blaine Amendment interpretation, you can have a tax credit program. Unless, as I've just discovered in Washington State, you don't have a state income tax or a corporate income tax. In Arizona, we have both, which brings me to the Wynn case. I'm not from Arizona, by the way. The program's a little screwy in that respect. I'm actually out of Arlington, Virginia. But neither here nor there. In Arizona, we have defended 3 different cases, successfully twice and unsuccessfully once. In Arizona, in Wynn, there is an individual income tax, and you can take a tax credit up to $1,000 on a 100% basis for donations to a scholarship tuitioning organization. There are 55 such organizations. They are organized in some cases by pedagogical method, like there's one for Montessori schools, but they are also organized in some cases on religious bases. Like there's a big Catholic tuitioning organization, there's a Christian school tuitioning organization, and then of course there's my favorite, because they wrote the best amicus brief in Wynn, the Jewish tuitioning organization. And what these organizations do is donations are made by individuals in lieu of paying a certain portion of their state income tax to these organizations. The organizations then act very much like the various private tuition funds, which is they give out scholarships to attend schools of that denomination, or to attend Montessori schools, or to attend schools in the Tucson area. This was challenged long ago by the taxpayers. We won all 3 levels of the Arizona state court system. Then the Arizona Civil Liberties Union found additional plaintiffs, filed again in federal court, and we're now at the U.S. Supreme Court, having lost in the Ninth Circuit, which, as you know, generally is not a good circuit. You're in it. The oral argument was November 3rd. We're awaiting a decision. We think that it's likely to be a 5-4 decision, similar to the way Zellman came out. And the whole issue there is that most of the scholarships are awarded by religious STOs for kids to attend religious schools. And the opponents would like the program to require that there can be no religious affiliation and limitations by the STOs. The problem is that unlike in a corporate tax credit program like in Florida, where you can get huge donations from corporations, you need to do a lot of work in Arizona to collect up to $1,000 from individual taxpayers. And what that means is that the fact that you can organize an STO around a group of religious schools gives you an enormous benefit in fundraising, in the same way organizing around the Montessori pedagogical principle gives you a benefit. And our opponents generally say that if what they regard as a disproportionate amount of the scholarships are awarded to students at religious schools, that violates the Establishment Clause. We argue that it does not, that in fact it's doubly insulated because individual families are choosing where they want to go to school and which scholarship funds they will seek a scholarship fund from, and individual taxpayers are making independent decisions of where to send their money. So we're hopeful that we will win that. If we lose, it will not be the end of the world, because we will be able to revise the program in such a way that it won't be as efficient as it is now, but that it will still be able to continue. So now I'll just shut up so that these other folks can speak. Thank you.
Didn't the donor indicate who the recipient ought to be?
No, they can only give it to them.
Yes, you move the microphone over by you. Oh, yeah. Well, my assignment has been to give a brief appraisal of federal constitution. Federal, I want to emphasize that. Federal constitutional doctrine, and I guess the possibility of future interpretations by the United States Supreme Court in respect to three different issues that have been talked about already by the panelists. So let me take them up one at a time. The Wynn case. I won't restate the facts. The Ninth Circuit did use a standard approach for appraising Establishment Clause challenges, which is a combination of the so-called Lemon test and the endorsement test. And they found that the Arizona program was wanting under both tests. They said there was a secular purpose for this program to provide scholarship funds to students going to schools, but that the effect was to advance religion because, as already mentioned, the highly disproportionate amount, 86%, was skewed to schools that favor religion. And therefore, they reached the same conclusion, a different conclusion, but the same analysis that Zellman used. Said since 86% are church-related or religious schools, there's no genuinely independent choice. Since there was none, the program would be viewed by a reasonable observer as government endorsement of religion, because that's where they were. That's where 86% of the money was ending up. They then had an en banc, the whole, I think of maybe 17 judges on the circuit, and a very close decision, 8 dissents from the denial of an en banc reviewal by the Ninth Circuit. So the major issue, as it indicated, I don't know if I'm saying much different, is how can it be distinguished from Zellman, which is a case in 2002 which upheld a system of vouchers in the city of Cleveland. Going to any accredited private school, you could use your voucher money, parents could, or I guess people have custody of children, could use the money at any accredited private school in the district, and in fact, 96% of the money ended up in church-related schools. As was the case here, the case turned on whether this was an effect that advances religion. And the court held it's not so. The statistics, they vary from place to place, from year to year. They used the Milwaukee situation to show that some years it was up, which was an older situation. Some years it was down. And therefore, since the aid does not go directly to the private school, but reaches it through a matter of private choice, then the perception of the reasonable observer is not government endorsement, but simply a ratification of simply the encouragement of a choice by a private recipient. I must confess, maybe I'm seeing it too narrowly. I think it's very difficult to distinguish the Zellman case. The aid here, the tax credit, and I wouldn't argue about whether it's money or my own simple economic view is money, and that's what you're getting. You're getting money in the form of a tax credit. It's not a deduction. It's 100% up to the amount, the maximum amount. It goes to the donor, however, not to the school. Just as the money in Zellman went to the parent and not to the school, which it was used. Although, as I recall, the system in Zellman was that the parent got his or her money in the form of a check, which could only be cashed after it was endorsed and sent to a particular to a school. So that was a pretty channeled conduit for the money. I don't know, no more so than this. So having said that, I would make a prediction, which is pretty, I guess, relatively clear. It's not altogether clear. You've got 4 justices on the court now who were not there with the time of the Zellman case. But I would think that there are going to be at least 5 votes to sustain the Arizona program. Justices Thomas, Scalia, and Kennedy, I think he will. He had no problem at all going along with Zellman, unlike Justice O'Connor, who wrote a separate opinion. He just joined the majority using that analysis. And although neither Chief Justice Roberts nor Justice Alito have really had any real opportunity to express themselves on this issue, I think they'll go that way. It's even possible that either or both of Justices Sotomayor or Kagan, they're unheard from, except on this issue, although their general ideological approach to questions is on the so-called liberal side. So that's that case. I'd like to talk a little bit about what the Blaine Amendments, how they relate to the federal Constitution. I think it's a very, very long shot to be able to find that the Blaine Amendment violates the Establishment Clause. And I think in response to the question of, well, how about showing that, that it was, and as Judge O'Connell said earlier, that it was anti-Catholic sentiment that forced it. The fact, I wouldn't challenge that for a moment, but I think it's going to be difficult to prevail. Doctrine is against it as well, but in the Supreme Court. But the fact is that it's used not against Catholics in many, many cases. And the case that I want to talk about, which presents a different issue under the Blaine Amendments, it was used against some Protestant denomination for a young man who did not get a scholarship given out on the merits by the state of Washington, because he wanted to use his scholarship to get a degree in devotional theology at a college in, did I say Arizona? I meant Washington, I'm sorry. So Washington has a so-called Blaine Amendment, provision in their Constitution, and they held that it was invalid under their Constitution to do this, and the challenge was that to deny him a scholarship based on his religious choice was a violation of the Free Exercise Clause, because it was a co-discrimination against someone because of religion. It's very difficult to deny that as a matter of fact, and the court didn't. Nonetheless, by a 7-2 vote, a case called Locke against Davey, 6+2000 in the late spring of 2004, the court held it was not a violation of the Free Exercise Clause. And the question is why? And they said, well, there may be, I didn't say it, but they never denied that there was discrimination here. But they said there's a, quote, play in the joints between the Establishment Clause on the one hand and the Free Exercise Clause on the other. And it was a 7-2 decision is not very frequent in this particular area. Let's say get 7 votes for the winning side. And it was a decision written by Chief Justice Rehnquist, whose task, successfully executed, was to get 7 votes. Well, that's not easy. He got not only Justice Kennedy, but he also got Justice O'Connor, and indeed, so he got those, and then the others. I guess there was. Wait a minute. There was one more. I guess he. Oh, Chief Justice Rehnquist. No. Thomas Scalia, Kennedy, O'Connor, and the four liberals. Excuse me. He did not get Justices Scalia and Thomas. They were the dissenters. He got himself and Justice O'Connor and Justice Kennedy and the 4 liberals on the court. Sorry to big ship with that. And it certainly puts limits on the question of whether there is unconstitutional discrimination in violation of the Free Exercise Clause if you give aid to parochial schools. But it was a very narrow decision. Much was left open. Especially regarding a program that made all private schools, which included all parochial schools in such a program. There was great emphasis on the fact that this supported church leaders, that is, the degree in devotional psychology, and phrases like, those with a religious calling were going to be supported by this, and there was nothing more clear from the history that there can be no, this I think was indicated by Judge O'Connell's luncheon talk, should be no religious funding for, quote, and I quote, religious training of the clergy, unquote. Well, that's not true in aid to parochial schools. On the other hand, this is also a use of the spending power. I would say, in the end, they will characterize these, whether it be grants or tax credits, or for that matter, tax deductions. And there's a very pervasive constitutional doctrine that you could do indirectly through the use of spending, but you cannot do directly otherwise. And that's something that you gotta look to. And I think there's also an open question as to whether, although not excluding parochial schools, that may violate the Free Exercise Clause, but if the prohibition simply says, but we will not permit the use of state funds to aid the religious aspects of the education that you get, that's very different. It's very different than a case like Zellman, which did involve money, which ended directly in the coffers of the school, but nonetheless was not even close to the total amount that the schools of Ohio got if they were public schools. And that's what distinguishes it. I see my time is up, I take it. So I'll do it in one last message without any footnotes. And that is, that also puts charter schools in a very different status, it seems to me, because they are 100% funded by the public schools. And although that does not automatically subject them to the constitutional responsibilities of the state, my guess is when the time comes, it will be sufficiently distinguishable that they will so hold, and therefore they've got to mind their P's and Q's in respect to what they do in those religiously state charter schools operated by religious institutions.
Okay, well, maybe we should just go directly to the audience if there are comments or questions that people want to raise or make of our panel. And Professor McConnell, I'm sure, will be one of the ones you can direct your comments or questions to, or we'll invite him to participate in the responses. So are there some people out there to whom I can get some participation? Joe.
Jesse, going back to the facts of the Wynn case, I think there is some distinction between what's going... Hello? Can you hear me now? I think there is some distinction in the facts. There are just, the way that money is being channeled now is mostly through, in Arizona, through religiously affiliated organizations. In the Zellman case, I had given testimony. We went through, very painstakingly outlined the range of choices that were available to students there. That it wasn't just religious schools supported by vouchers that they had a choice of. We documented charter schools, we documented other kinds of choice options that were available to the students that I think the lawyers around the case thought was very pertinent. And so, do you see any, I mean, I wonder, other people on the
You
panel.
mean the magnet schools and?
There were magnet schools, there were charter
schools.
We went through it school by school to document for Sandra O'Connor
Yes.
that there was a range of choices available. It's very hard to make the same argument, I think, in the present case. I'm not trying to predict what the court's going to do, but I think the facts are slightly different.
Yes. That's possible. I think if you went back even before Zellman to the original case, the name of which I now forget, from Minnesota in the early 1980s, Mueller versus Allen. Thank you. That was a case of a tax deduction in which, for some reason, I have the figure 96% also ended up in the coffers of the church-related schools. And that's where the court, again writing through, I think it was then Justice, yes it was, then Justice Rehnquist, writing for a sharply divided court, said that statistics aren't going to tell the story here as to where it ends up, which he, of course, used in his opinion in Zellman. So you're right. And you know, with Justice O'Connor, I'd be a bit more inclined to think more carefully about what you said, because her hallmark was looking for the narrowest ground possible, just as the notion that it's a matter of independent choice. If you give the check to a parent and make him or her endorse it over to a school, now I see that as purely a matter of form over substance. The parent also makes a big choice as to which school they send their kid to. That's where the choice is made, not where they send the money. But she did, and it was all her. It was all her theory that used this dividing line, which I don't think, I guess I don't think many of the justices saw it, but they had good reason to follow her, as they needed her vote.
Are there others on the panel who want to talk about whether this difference in the facts of Wynne is frightening for upholding the statute?
Well, I think there is a slight difference, whether it results in deciding the case differently, I don't know, but the difference is this, that in Zellman, the parents, if you qualify for the program, you choose your school and you get the money, whereas in Arizona, it is the tuition scholarship organizations that decide which schools are going to support, and so it actually isn't a parental choice program at all. It's a taxpayer choice program. Now, I think that shouldn't make a difference for the Establishment Clause, because I think the only important question for the First Amendment is whether it is the government that's channeling the money. But it is different in that the parents in Arizona are, in fact, it's really not an individual choice program, unless it does, I think, fall somewhat outside of Zellman.
I'd like to answer also, since we litigated Wynne. And we did make that argument, actually, because for those of you who know, Arizona has the greatest freedom of educational choice of any state in the nation by a huge factor. Per capita, they have far more charter schools. In fact, only California has more charter schools than the piddling little state of Arizona, which has over 500. But we made the argument that, in fact, parents in Arizona have all kinds of choices. They have full public school choice. They have magnet schools in Arizona. They have traditional public schools as well as other options. And, you know, it's not like we didn't put a chart in Zellman that showed all the different choices people had. We did the same thing in Wynne. Of course, Judge McConnell's completely correct that it's a different program. But we were, in fact, responding to the opponent's point that, look, there's all these people going to religious schools, by pointing out that you know, in Arizona, they have far more secular options than religious options, and than any public school kids in other states have. So yes, we used that, and in fact, one of the amicus briefs, we assigned this one to the Goldwater Institute in Arizona, in Phoenix, to support that with statistics, et cetera. So we used the exact same approach from Zellman.
Maybe I can take the opportunity to ask a question, because I'm very interested in Judge McConnell's view of what's happening in the TISA case. Maybe because I came out of the charter school industry most recently, and I'm interested in what your perspectives are on the parents' rights and how that is moving forward.
I could talk all day about the case, but I'll try to be very brief. As Eric indicated, this is the first sort of religiously related charter school establishment clause case, and it arises in St. Paul, Minnesota. TISA Academy has a student body which is entirely from recent immigrants from the Middle East, meaning Somalia is the largest single population, 20 different countries, Bosnia, Pakistan, lots of different places, lots of different language groups. Most of the kids, 80% of them, below the poverty line and eligible for school lunches. 70% of the kids English as a second language. And the school accommodates Islamic religious practice in a variety of ways that I'm about to mention. So this is what I care about as an establishment clause matter. And so the question is going to be, what other than actually teach, if a school doesn't actually teach religious doctrine, and so far as I can tell, the school does not. In fact, most of the teachers, very few of the teachers are Muslims. So I don't think it teaches religious doctrine at all. What else might it do that would run afoul of the Establishment Clause? And this is what they do. As you may know, Islamic people are required, all of them, to pray daily at a specific time, 5 times during the day, but at specific times. I think it's within an hour window, and one of those times always falls during the school day. So the school ceases operations for 5 minutes, then the kids who wish to perform their prayer obligations. It's not school-led, it's just a cessation of school activity so that they are able to do that. They are all, Muslim people also are required to attend a communal worship service once a week on Friday. That also is specific within an hour window, and it takes a little bit longer. And originally the school ceased its activities for half an hour under pressure from the state government. That's down to 10 minutes. Kids who want to do it go to a particular spot in the school, and one of them leads, usually an 8th grader. This is a K through 8 school, and usually an 8th grade boy leads the worship service. So there's that. Then there's the school lunches do not serve pork. If they did, the kids couldn't eat it, or at least the ones who are Muslim couldn't eat it. They observe the school calendar conforms not only to major Christian holidays, but also to the 2 major Islamic holidays. They meet at other days. It's not a shorter school year. It's just that they don't meet on the 2 Muslim holidays. They have a modest dress code, and the possibly the most controversial thing has to do with the aftercare program. And the significant point here is that the buses don't leave the school until an hour after school ends. And during that hour, the students are given a number of opportunities, some of them secular, Boy Scouts, Girl Scouts, but a majority of the students traipse next door, and the campus is literally, it's really almost one building where there's a mosque attached. And the kids traipse next door and have religious instruction under private auspices at their own expense, not funded by the state, if they wish to. And the ACLU has sued, saying that this is an unconstitutional arrangement. Their theory is that although any one of these accommodations might be okay, or any two, I mean, they don't really, it's not very clear, but the combination of them makes this look like an Islamic school, and that's unconstitutional. By the way, I didn't mention that they also do teach, all the students take Arabic, modern Arabic, as a subject, although oddly, that's not, in the ACLU's complaint, that's not one of the things that they say is problematic. It may come up in the thing. So I have volunteered to represent the parents intervening. We are worried because the school itself is represented by an insurance company, and there's and they are under a lot of pressure to settle in order to cease the expense. And the problem is exacerbated by the fact that they're suing under a federal civil rights statute that entitles the ACLU to have its attorney's fees paid if the ACLU prevails. They have the largest law firm in the state of Minnesota representing the ACLU in the case, and according to newspaper accounts, it is the most, they have spent more money than the ACLU has ever spent on any litigation in the state of Minnesota, over $2 million already, and we're not even past the summary judgment, or we're just barely past the summary judgment phase in the litigation. So they are piling up their attorney's fees, which hangs as a threat against all of the defendants and an enormous inducement to settle. And so my clients, the parents and children, are worried that unless they are able to present their own religious interests, that the insurance company will settle on the ground and eliminate some of what we think are constitutionally appropriate and maybe even constitutionally required accommodations of their free exercise of religion. The district court has been extremely hostile to the school, and refused to allow the parents even to intervene. My first step in the litigation when I entered it was to write a brief and then argue in the Eighth Circuit against that it was improper to keep the parents out. And I'm expecting any time now, it could even be today, pretty soon, I'm expecting the Eighth Circuit to decide that, and feel pretty good about the prospects that we will then be in the litigation. That means that the parents will have some voice in being able to defend these religious accommodations.
Thank you.
Yes, in the back.
Andrew Colson, I just wanted to touch on the question that was raised a couple of minutes ago.
Speak
about
a little closer, Andy.
Right, about whether or not the program in Arizona, the tax credit program, is merely a program of taxpayer choice rather than a program of parental choice as well as taxpayer choice. You can answer that question in part empirically. Just look at the distribution of scholarship organizations in Arizona and the distribution of families. And we did that in the amicus brief that we filed, that the Cato Institute filed, and found that it's really quite similar. That there is not a preponderance of scholarship organizations dedicated to particular religions or to religion over secularism that is out of proportion with the citizens of Arizona. For instance, there are many more scholarships available for secular schooling in Arizona than there are secular families in Arizona as a ratio. So right now, it is not a program that denies choice to families. There are as many options for people of any given faith as any other. But in the long run, much more importantly, and this was the point that I made in the end of our amicus brief, this kind of program, this kind of scholarship tax credit program, which has a proliferation of different scholarship organizations, is the kind that is most likely to preserve parental choice. Because historically, all third-party funded education systems have eventually been quite heavily controlled by the people who fund them. And it hasn't mattered whether it was a single private funder or whether it was a government funder. Whoever pays for education tends to control what's taught. So when you have a single provider, as you do under a voucher program or under a private program that had a single payer, that single payer would control what's taught. When you have a proliferation of different scholarship organizations, parents have the option to escape from whatever rules are imposed by any particular scholarship fund. There are something like 80, I think, in Arizona, and there may be something like 140 different scholarship organizations in Pennsylvania. So parents can escape whatever rules are imposed by any one organization. And there is no other way of providing third-party financial assistance to parents that preserves that level of choice in the long run.
But it does remain to be seen how unregulated this program will remain by the legislature.
So I'd like to ask our panelists this question. Assume now with me for the moment, this is sort of to get Jesse's attention, that the charter schools get 90% as much funding as the regular public schools, which is actually more than they get in a lot of places, but let's assume that for the moment. And let's assume that nobody is going to a charter school to be trained for a religious vocation for the moment. And and now the question is this. I would assert, as part of this question, you may have to think about whether you agree with me or not, that public schools traditionally have a kind of a top-down view of life in which government speaks through its adoption of things through its public school system, and it has its strong free speech rights to speak and so on in that way. And the charter schools are conceived of as a bottom-up kind of strategy where all sorts of diverse people can come forward and start their own schools at public expense as opposed to the top-down. If you were to accept all those things, now my question is this. The one thing you can't be now as a charter school is a religious school. So why isn't this blatant viewpoint discrimination that ought to trump establishment considerations and therefore make it be unconstitutional to exclude openly religious schools from getting charters? Now, if this claim were successful, one possibility would be the elimination of charter schools. Someone raised the question earlier today about that, political backlash against this. Nonetheless, I want to raise the question whether or not, as a constitutional matter, isn't there some room to try to get rid of this clear discrimination against religion that we see by simply placing the label public on these charter schools, which in my characterization represents something different. It represents, as in Rosenberg, a kind of letting people from the bottom up have what they want. So what do you think of all that?
Well, there's a the major difference between Zelman, which is the critical decision upholding significant allocation of funds to church-related elementary and secondary schools. Is this, what I've suggested before, is a very weak distinction between the money going directly to the schools and not going to, now it goes directly to the school in the charter case. The weakness of the distinction shows how, if you just change the form a little bit, it doesn't have to go to the schools. It can go to the parents who want to send their children to the charter schools, and you give them a voucher worth 90 or whatever %. It is for that reason that I think that in the end will not be a big distinction if the money goes straight there. I don't think that's going to make any difference with Justice O'Connor gone. Having said that, what the schools can, if you can remove as best you can the characterization of that they are public schools, I mean, that's the critical thing. If they're public schools, you got a bunch of different problems. For example, in your case, if they're public schools, and you know, in the public's image, that, excuse me, in the public's image, that's what they are. They're public schools that are wholly funded by the state. Certainly that was my image. I mean, this is not my area, but if we're a public school, I would think that if I were the ACLU in your case, I would say, well, what you're doing when you give 10 minutes every day here and 40 minutes or whatever it is at another time, is you've got an on-premises release time program in which the court has long held is a violation of the Establishment Clause for a public school, in which if those children who want to go to religious classes or ceremonies can, and the others got to sit behind, and they held that that's, you know, invalid. I'd be concerned about that. I think there are ways to, again, try to fool with that as well. Have them have a range. I don't know what the percentage is in these schools. If they're 95% of a particular religious denomination, that's one thing. I would think in a number of them, they're not going to be charter schools, just simply because they're church-related. They're, you know, for example, racial minorities often believe they get a better shake in a better education, is what I meant, in a private school than otherwise. But those are the things that I would that I'd be concerned about. But I think the fact that you can say this is not government speech, that I think, although again a very, very difficult distinction as to what's government speech and what's government sponsorship of private speech. But it's not bad. The charter schools, one of the big notions is we want to differ, we want to improve the quality of education, and we want to improve different ways of delivering it and so forth. So I think that's a very strong point you got.
I'm sorry, I couldn't resist, but stick. We're Fame Public Charter School. I introduced myself earlier, and I find a lot of times when I go to conferences, they actually take the public out of our name, although our name is actually Fame Public Charter School. In California in 2005, it was a requirement that your charter petition included the word public somewhere very clearly in either the introduction or the name. And we went so far as to make sure all our signage, all our flyers, everything said public. I don't know how other states work, but I know in California we're funded fully by the state, and we're funded based on instructional day. And the instructional day is broken down into instructional minutes. You don't get paid 1 cent for any minute you are giving additional instruction unless you're actually applying for supplementary school instruction for after-school instruction. So I know that, for example, you know, in charter school world in California, we're compared in terms of a student-to-teacher ratio and some other statutory requirements to the largest school district in our county. And the largest school district in our county, Oakland, actually gives prayer release time. So it doesn't matter what your religion is, you can have prayer release. Our school runs Monday through Friday. We do have a half day on Friday, and that allows our Muslim students to go to prayer or do whatever they want to do after school. That's not the only reason we have our half day Friday, but we were challenged on that, and we said, you know, what is the logic between the half day on Wednesday? The local district had a half day on Wednesday. It made no sense to have a half day on Wednesday when in the Bay Area Friday traffic was the worst traffic and people wanted to get home, you know, people wanted to get home early. But I just wanted to kind of throw that point out there, because if it's about money and state funding and you're not getting paid for any supplemental time or any additional instructional minutes, then there shouldn't be a problem allowing kids to pray. We allow kids to pray. We don't have a time that we stop the day or release the kids during the day. We just make sure the lunch period is long enough so that if they want to pray, they have sufficient time to eat, and then they can go and play. They can play basketball, they can pray, they can do whatever they want with their lunchtime period. So I think frequently when we hear arguments against, you know, religion and what are they doing and is this allowable, I mean, is the state really paying for it? the state's paying for a defined set of instructional minutes, and that's pretty much it.
I just want to say one thing. One of the problems about people who are doing what I do here today, and that is reporting on what the court's decisions say. I'm not evaluating them, except that are little side comments. I'm just a reporter. And in this area of church and state and the Establishment Clause in particular, at least my own view is that logic is not a compelling consideration. And as has been said, you know, in one way or another in some of the major decisions, it's a matter of degree, all right? Well, that means it's a matter of how a particular majority of justices see it. Or, as Chief Justice Rehnquist said in the Washington case, in the Locke case, says there's a play in the joints. That was a quote from an earlier decision upholding property tax relief for religious institutions along with other nonprofit ones. But it just gives a great deal of flexibility to what things are like. So if you want to say, well, I don't understand it, I guess as an old colleague of mine once said to a student who gave him, kept asking the question, he says, I can explain it to you, but I can't understand it for you.
You answered, Doug Tuthill. Dick and I had a conversation today on the phone about this, and I left the conversation convinced that there was not logic involved. I mean, it was, as much it was semantic as anything else, A Catholic school could have 100% kids funded on our McKay Scholarship Program, and that's fine. But if they contract with a school district to become a charter school, then it's not fine, And the difference was the word public, okay? So if I changed the state law in Florida and called them private charter schools, would that fix it? Maybe, I don't know. If it's all semantics and illogical, who knows? So
Justice O'Connor would say that much more lends itself to the perception of the reasonable observer that this is a state endorsement of what is being taught in the schools. Steve Sugarman put that in a somewhat more elegant way, I think, in saying that what goes on in a public school is government speech, and what goes on in a non-public school is private speech, and therefore not subject to the same constitutional strictures.
There's a lot of illogicality in First Amendment, as there is in a lot of other areas too, but I just like to, maybe I'm naive, but my sense, I've been working in this field for 30 years, and my sense is that when something doesn't make sense, over time, it's more likely that the court will shift on this than if it does make sense. I mean, it's a long-term proposition, but being illogical is, it's like having, a grid in your system, and they do eliminate stupid illogicalities from time to time. So that's what we want to work on. And
So my view about that, Mike, is that in the 70s, the Supreme Court viewed these aid to education cases as designed to help Catholic schools, and that had a kind of a particular religious thing, even though there's a lot of things you could say about them and so on. Now they see choice as about improving education generally, helping poor families. There's a different kind of narrative framework around which this is understood, even though it's importantly understood, of course, to include families choosing religion if they want. But nonetheless, I think there's a kind of a shift in the sort of national understanding of what politically we're about here. And this new perception, this is about all families getting choices. That's why we're trying to legislatures doing these things, I think gives it a different feel and helps the court kind of see it, and helps the public see it in a different way than they may have seen it 40 years ago. I don't know if you think that's right, but I think that's
I do think that's right. And another thing that has changed is that we now have 6 Roman Catholics on the court, and that makes a difference. I mean, when Lemon versus Kurtzman is decided in 1971, William O. Douglas, in his opinion, actually quotes from a notorious anti-Catholic tract. I wish I could, recite some of it. It has just absolutely outrageous stuff in that. I mean, he doesn't literally quote the outrageous stuff, but he treats this anti-Catholic diatribe tract as if it is an authoritative explanation of what goes on in Catholic schools. Nobody would do that today, I don't think. I think that is now, that would be regarded as shameful.
The other thing I would add that's changed is just that America has become a much more religiously diverse place since that time, and that it actually makes it easier to make, at least from the practical standpoint of litigating one of these cases, it's actually much easier to make the case when you're dealing with an unfamiliar religious minority, because then people actually get to the abstract principles that are supposedly guiding their decisions, rather than thinking about it, well, this is good for the Catholics, or this is good for the the evangelical Protestants, or what have you. They say they don't really know anything about the Sikhs, so they just say, oh, okay, maybe I need to follow these principles here. So I think that growing diversity actually in a lot of areas regarding both religion clauses is helpful.
Okay, well, I think we should stop and take another break. Is that right?
Could I ask one question?
Okay, Jim, yeah.
Jim Spady, Fawn's husband. My question is for the gentleman from the Institute for Justice on a technicality about the tax scholarship thing, the state credit. Does it matter whether the state gives you credit for 100% of your donation to the scholarship organization, or is it constitutionally safer to give 90%? Or could they do, say, 70% and let the federal government pick up the rest of the cost through, because it's a charitable donation?
That's actually, it did come up and is a component in WIN, because our opponents, the Civil Liberties Union, assert that because it is 100% tax credit up to the ceiling of $1,000, that therefore it is all state money. And this is nothing but a voucher program in disguise. We, of course, disagree, because would a 99% tax credit be any different? I mean, the argument is, even if it was a 70% tax credit, well, then 70% of the dollars that are going to the STOs could be treated as public money and subject to Arizona's Blaine Amendment or to the Establishment Clause. So for us, it's kind of an all or nothing business. And personally, it makes a big difference to taxpayers. If it's 100% tax credit, then they're much more inclined to do it than if they're only going to get 50%, as some of the current tax credit legislation that I've reviewed says. So for us, we don't see a distinction. The Walls case, which involved property tax exemptions, which Dean Chopra referred to, those are 100% tax exemptions for your property. They're not 70%. They're 100%. And so we don't see the fact that it's 100% as making a difference, but they certainly like to focus on that. Thanks.
Okay, well, thank you very much for your panel.